Thank you.
Let me make sure. Yep, you're connected.
Okay. And I thanks Professor Tebow for inviting me here today. He and I, as you know, are both lawyers. I have, throughout my career, I've practiced all kinds of law. I've done bankruptcy, domestic law, which I hate. I would encourage people to get back together and not divorce, and it just wasn't in my heart. With criminal law, though, I generally know, and quite frankly, probably 80 to 90% of most criminal defendants, in fact, are guilty. And so, of course, the question rises, well, how do you represent people you know or that might be guilty? Well, number one, I'm not the judge. I'm a lawyer. We take an oath to the bar to render a zealous advocacy. That means to don't judge your client. Do your best to see that his constitutional rights are protected, that he receive a fair trial. Now, I plan to tell you a little bit about myself, how, like Professor Tebow said, how I became a lawyer, and then we're going to open it up for those of you who are still awake to ask questions, and let Professor Tebow also ask me some questions. But he and I both love the law, and he's one of the best adoption lawyers in town, which gives people a lot of joy. And he does domestic work and probate work, and a lot of times he and I both represent people who, quite frankly, can't really pay a fee that's what's worth, but we're supposed to do some pro bono work, which means free service. So anyway, I was born in Columbus. I attended local schools, Johnson Elementary, Arnold Junior High, and Jordan High School. And then I received a tennis scholarship to Columbus College at that time. This was the last 2 years it was a junior college before becoming a university. And oddly enough, we were fifth in the nation. We had a really good tennis team. I was in love with a girl that graduated from Columbus High, and she wanted to go to West Georgia. And I dropped a tennis scholarship to apply to West Georgia. Well, they accepted me because I had good grades. She didn't make it because she spent high school looking into her compact. And when I got to West Georgia, there were 4 girls for every one guy, so you can sort of guess what happened to that relationship. Um, anyway, I was majoring in pre med at the time at West Georgia, and actually had got a withdrawn failing from a physics class. And at the time that I was withdrawn failing, it was because I could not get up at 7 o'clock in the morning for the physics lab, or I didn't like to anyway. So I was attending the 3 o'clock in the afternoon lab, which is more in line with my nightlife. And found out later that the teacher was not giving me credit for the afternoon lab because I was supposed to be in the morning lab, even though it was the same thing. Well, that didn't seem right. Then I was called for an interview at the Medical College of Georgia, which means they're considering taking you. So I had a beat up car. I had to drive from Carrollton, Georgia to Columbus to get my mom's car, to drive to Augusta, and then have the interview and drive back to Columbus, get my old car, and head back to Carrollton. And I missed the next morning lab. I came in the next day, he said, "You're withdrawn failing." I couldn't talk him out of it. I went to the dean. He said he'd speak to the professor. But anyway, and oddly enough, this led to me becoming a lawyer because my college roommate had a vehicular homicide. They took his license immediately. He was from Atlanta, and I had to drive him into Atlanta because he had no license to meet with his lawyer to defend him in the vehicular homicide case, which he wound up doing 3 years in prison on. But I was talking to a younger lawyer in the firm, and I came from a regular middle class family. I mean, my mom and my dad both worked, and uh, I one time wore hand me down clothes and had baseball shoes with holes in them, and so I have an appreciation for those that maybe are less privileged. Um, anyhow, that lawyer told me about night law school in Atlanta, and I thought that I'd seen ads, and I figured it was a gimmick. You could go and get your night law school degree, but you couldn't ever be a lawyer. And I found out that Woodrow Wilson College of Law that I attended, that at that time, a majority of the Superior Court judges in Atlanta area were for graduates of Woodrow Wilson. We were fortunate because University of Georgia and Emory and Mercer were teaching theory. We had practicing attorneys. Like my trust teacher was the senior vice president of the Trust Company of Georgia. My criminal law teacher was one of the best. He was a wealthy fellow from Noonan, and as a hobby, he defended death penalty cases all over Georgia. And what he would do is he would go in and paper them to death and motion them to death. In these small counties, it was just about too expensive to litigate against him. And he started getting people maybe life in prison, which is still a victory when they were facing a death penalty. His name was Millard Farmer. He's dead now, but we had a lecture series from Al Horn, who at that time was the best drug lawyer in Georgia, Glenn Zell, who represented all the massage parlors and strip joints and everything in Atlanta, which taught me a lot. Lecture series from the from the medical examiner of Atlanta, and people who were regular practicing lawyers, which I think gave me sort of a heads up on practicing law. So anyway, I forgot to thank Professor Tebow for calling me here. One of the reasons, there's two reasons I'm thankful. One, I love the law, and it gives me an opportunity to talk about it. Secondly, my daughter works at Aflac, and she is an online student in this class tonight, and she's very intelligent, opinionated, and we disagree all the time but love each other dearly. I'll give you an example. She's 120% behind Trump. I'm for Harris. And we get in arguments about that. I says, let's stop. But he's given me the opportunity to speak for a while without her interrupting, which is unique. So I hope you're seeing this tonight, Blakely. Anyhow, I love the law, like I said. When I did graduate, I had a history degree and a minor in urban administration, like city government, city managers, mayors, things like that. And but when my roommate had that vehicular homicide, I didn't take that. I got interested in the law and I was fortunate that I was having to work my way through. I had a scholarship here that I dropped stupidly. And then when I got to West Georgia, my mom and dad helped, but then I wanted to join a fraternity. I said, no, we ain't got enough money for that. I started working weekends in Atlanta at freight lines, unloading trucks and loading trucks and all of that. And I worked my way up into the Teamster Union. And back in 1978 or 9, probably the last year I worked in the freight lines, which paid my way through law school and the rest of college and allowed me to be in a fraternity. Well, a majority of the students in West Georgia were from Atlanta. And so Wednesday night we call hump night, and that was when all the fraternities had parties, and that was a real party night. And the school was a ghost town on the weekends. But I'm in Atlanta going to work Friday night till early in the morning, then going in Saturday at noon and working. And then Sunday I would come in at 12, but they would let me go at 6 because I was a college student. But back then, because of the Teamsters, I was making $14.25 an hour, which was a lot of money back then. It enabled me to pay for college and law school. So I have an appreciation for people that have to work for what they get. And it also kind of taught me, and it should teach you, that, I came from a middle-class family. Tom will agree with me, a majority probably of the lawyers, fathers are doctors, lawyers, bankers, things like that. But, if I could do it, all of you can do it. Whatever you want to be, you have to sacrifice some, you have to put in a lot of hard work, but any of you can generally achieve the goals that you seek, okay? So anyway, so you know how I became a lawyer, and part of the reasons I went to law school is I had a college degree. I wanted to come back home to Columbus. I've always been loving Columbus. My family goes back here. In fact, I had a great great uncle helped build the first 8 log cabins in Columbus in about 1823 or 24. So my family's been here a good long while. And then my mother's family was real prominent in Alabama. In fact, her first cousin was Supreme Court Justice in Supreme Court. Sonny Horn was his name, Sonny Hornsby. And so I guess some law is in my family, but I wanted to come back home, and I figured I didn't want to sell insurance, and I didn't want to teach school. What the heck could I do to come back to Columbus, Georgia, other than work in the mills at that time? But with law, I knew I could come back. I did come back. My first, and I started solo. wasn't in with a firm. I had to kind of pick it up on my own. My first desk was an old school desk that I sanded down and refinished. Behind me was about a 1940 something console. It used to have a TV on one side and a stereo on the other. It was called a German. It was made in Germany. The furniture was beautiful. It was hand carved and everything. And I ripped out the TV, ripped out that. I had a long cardboard box with files in it. That was my first file cabinet. And I can remember calling home and asking my mama to call me to make sure my phone was ringing. That's sort of, and I moved back into my old childhood uh, bedroom. It was the big time lawyer, and I was driving a car that was so old that the driver's side door wouldn't open. I had it wired shut and had to crawl over the console and get out the other side. That big time lawyer living at home. But I persevered, and here I am today. And you can do it too. My first case, oddly enough, was a murder case, and I lost. Uh, Followed by 3 in a row victories and 2 armed robberies and a burglary, which led Judge John Henry Land, who was a big judge here at one time, to appoint me as the second chair, meaning the second lawyer, for the Strangler case. I don't know if you ever heard of the Columbus Strangler. And I went up there and I begged him. I could only see that that's all I'm going to be doing the next year. I'm not going to make a living. What else can I do? I went up there and I told the judge all the conflicts. My mom and dad had dinner with Fern Jackson, who was one of the victims. I went out with Ms. Woodruff and Ms. Scheibel's granddaughters. I said, Judge, I got this conflicts all over that. You'll do fine, Bobby. So then I danced a jig just about when the there was a federally funded death penalty lawyer that came in and took over the case named Stephen Bright. Whew, boy, and I was glad, because if anybody knows about that case, it went on for years. And so then my first civil case, there was a big law firm here. It was called Hatcher Stubbs. Madden Hatcher is one of the best lawyers. He's still practicing some in Columbus. He was on the other side. So my first criminal case was a murder case. My first civil case was against one of the partners of the biggest law firms in town. And the man that was letting me practice with him after I'd already been in there maybe a year at that time or something, he said, well, it's all downhill now. He said, you've been against a murder case and one of the leading civil lawyers. He said, you'll do fine. Well, I did. And I've enjoyed the practice of law. If you think about it, you always hear the word rule of law, but laws are what keeps chaos from being in society. If you follow the laws, if you think about it, all the major religions, like you think of the Old Testament, the Bible, the Quran, in Islam, and the Torah, and the Jewish religion, all have books of laws in there to teach people how to kind of act. And one of the oldest was Hammurabi, is Hammurabi's Code, and they still follow that. We're supposed to be dedicated to do justice, to seek truth. I came out of school wanting to seek truth and do justice. And as a criminal defense lawyer back then, now we've got a good district attorney's office now, and thanks to laws and Supreme Courts and the Court of Appeals and the many lawyers in the legislature, we're on a much more level playing field now. It used to be trial by ambush. The DA would come at you he would have statements you didn't know about. He would basically withhold evidence from you, something that would help your defendant, they wouldn't tell you about. And it was just really unfair. But thanks to the rule of law, these things changed. Back in the 60s, before Miranda v. Arizona, the cops could just take you in and hold you for a few days, and rumored beat you with rubber hoses and whatever to get a confession out of you. There was no protection for you. There was no protection against search and seizure. The cops could pretty well come into your home and just look around and do what they wanted to do. And then while I was in college, of course, marijuana became sort of here. It had been on the West Coast in California. Like always, it starts out there, and then finally it gets down here to Hick City or whatever. And a lot of my friends were getting busted for drugs and stuff. And I said, well, well, a lot of my friends need lawyers, maybe this will be good for me. Uh, so anyway, I have enjoyed the practice of law. Um, and Professor Tebow said maybe tell you about some cases or some things. But if you think about law and the importance of law, there's still, there's always been discrimination in this country. And we, even though our Constitution says we're all created equal, well, that may be true in God's eyes, but we were not treated as equal, especially people, Afro Americans, other minorities. Many times were given the short end of the stick, so to speak. But what made it better for them? Laws. That just people just being courageous and wanting to change, wanting to do what is in here right. And so what do lawyers get to do many times? They get to dispel the wrongs and to stand up. If you think about it, a criminal defense lawyer, let me just say something else. I always get asked this question, well, how do you represent guilty people? Well, number one, again, we take the oath to represent them and to the best we can. Not to, I'm sort of like the old Green Berets, kill them all, let God judge them. Well, I represent them all and let God decide what they'll happen in the hereafter. But anyway, I started out, and as a young lawyer, you take about everything comes through the door just simply to pay the rent. And I had won some child molestation cases, but as my practice grew, I didn't have to do that, so I didn't like those kind of cases, so I just quit taking them. I didn't like domestic cases, and as my practice grew and I saw that I could actually make a living being a lawyer, I quit doing them too. And it wound up that I mostly do criminal law. Historically, I did criminal law, but my probate practice is kind of higher than that. And then I represent one of the largest real estate companies in Columbus, and I do all their closings and the landlord-tenant work. And so now I'm able to sort of practice at what I want to do. And if I don't feel good in here about a case, I just don't take it rather than lay down and represent them. And so law is important because it, like I said, has really made the rules for our societies. And it always has been that way, except it was law, even today, is ever evolving. You see wrongs, you try to make it right. And so you get a lot of joy and strength from being able to help people. So even though I'm a criminal defense lawyer, I look at it like sometimes, even though a lot of the people are guilty, that I'm still helping their families. I'm seeing that even if they're convicted, that they got a fair trial. And there's an old saying that, and I think, well, there's an old saying that's better that 10 guilty people go free than one innocent man go to prison. All of you probably have seen in the last few years, thanks to DNA, of all the many people who were wrongfully convicted that were serving life sentences and all. Why? Because a lot of times they either had a underfunded public defender that really wasn't that good of a lawyer. Sometimes they've got good public defenders now. Well, they pay them decent now. They used to not pay them hardly anything. And so law is important. Professor Tebow asked me to say something about some of the cases that I represented. I don't want to toot any horns, and I don't want to get too much in depth to that. And I probably have to go back, and I'm sure I've forgotten many of them. My daughter Googled my name or something like that last night and came up with a whole bunch of old newspaper clippings of cases I even had forgotten about. But some of the things that I remember in law is one time I was trying a murder case, and it was kind of like the old if it don't fit, you must acquit case. Let me give you another example. I was trying a trafficking and cocaine case, and it happened down in what used to be Booker T. Washington Apartments, and they had a black leather jacket, and so I was able to get it, and I looked in and I saw the size on it, and the evidence was pretty strong against my client. And then attorney Mike Garner, who's one of the best criminal lawyers in the city, had the other defendant. And this is what is unique about this story. But so I asked my client, what size do you wear? and he was 2 sizes too big for that jacket. So this is even before the O.J. Simpson case, but it don't fit. You must have quit on the glove, But anyway, we wound up trying that case, and they brought the jacket out, and I had my client try it on. Of course, he couldn't get into it, and so we concluded the case. The jury came back and said that Mr. Garner's client was innocent and my client was guilty. The next morning, my phone started ringing off the hook. People on the jury were calling, wait a minute, that's not right. We wanted to convict him and your client was supposed to go. They had a football coach was a foreman of the jury, and he got it confused on who was what. And so I went to see Judge John Allen, who was a really fine judge here in Columbus. Judge Allen's kind of like me, except he was worse. He grew up in BTW, a housing project. He played some sports and got a scholarship to Tuskegee University, and wound up becoming a fighter pilot and honorary member of the Tuskegee Airmen when he was a fighter pilot in Vietnam. He flew many missions. You would never know it from talking to him because he was just really an easygoing, fine fellow. But I told Judge Allen about how I got all these calls from the jurors, and he was a fair judge, and he said, I'm going to reconvene that jury, and he did. And he had the whole jury sitting up there, and he said, this is why you're here, and this is what Mr. Jones said, so I'm going to repoll this jury. He says, juror number 1, what was your verdict? It was not guilty, Judge. And they went all the way through and found out there had been a mistake. So unfortunately for Mr. Garner, his client went into jail. My client came out of jail. So that was kind of a funny story. I did win a murder case one time. The hat was the main evidence, and I really thought my guy was innocent, and I won. The case was over, and he said, Mr. Jones, does that mean I can get my hat back? And I said, oh, my goodness. And I'll tell you, there are people that I've represented that I thought were innocent that were guilty. There's people that I represented that were guilty that I thought was innocent. And so what did that teach me? Don't judge each person, and don't let your representation be dependent on what you think of your client. You are under an oath to give them that zealous representation and to see that their constitutional rights are protected. And that's what I've always tried to do. I don't know of a whole lot. Let me see if there are any other one time we had a murder case. It was inside Rutledge Correctional Institute out here, the prison. And I filed some unique motions in the case, and it's the only time I know of in Columbus, at least, that the motions were granted, and the judge recessed, reconvened the jury the next day. They loaded up on buses, and we took the entire jury into Rutledge Correctional Institute. They locked everybody down. We went on into the dorm where this horrible murder had happened, and let the jurors see everything in there. And anyway, that was kind of a unique thing. There was a case called Batson v. Kentucky that said, and I'll tell you why this came about. Back in that day, if you had a black client, the DA would strike all the Afro-American members of the jury. If you had a white client, he'd strike as many white folks as he could. It wasn't fair. And there was a case in Kentucky called Batson v. Kentucky that said whenever jurors of a cognizable race are stricken, that upon a motion from the other side, that lawyer who's stricken those people has to give a race-neutral explanation of why he struck them. So I read this case. Oddly enough, a week later, I had an armed robbery trial, and it started out, and that's what the DA did. He struck all the black folks on the jury. And I made this motion, and the judge up there, Judge Wisden at the time, he says, and Mr. Bray Conger was the DA, but he said, and I made the motion, Judge Wisden says, I've never heard any nonsense like this. What do you say, Mr. Conger? Well, he stepped right in the bucket. He said, Judge, I don't even know who I struck, let alone why I struck him. We went on and tried the case and lost. It got appealed, and guess what? Under Batson v. Kentucky, it got reversed and brought back. And because of the judge didn't want everybody to see how he screwed up the case, so to speak, from not reading the Supreme Court cases. They just kind of went back. He saw me sitting out there because I was interested in what was going to happen. He said, I want defense counsel and the DA and to come back into chambers. And I got up too and said, not you, Mr. Jones, and took them in there, and they made a deal. And this guy who had 20 years, he had been sentenced to 20 years in prison. It was an armed robbery with like shotguns and co-conspirators and of a real estate company here in town where they jumped over, they terrorized all the people in there and all. Well, because of that case and because the judge and the DA didn't want to kind of come out in the paper looking like, what really happened, and also not to educate all the other lawyers about this case, so to speak, they agreed to give him 10 years to serve credit for time they'd already been in there, and he did about 4 more years and got out. So he would have had 20 to life. So I'm sure there are other cases. One of my favorite probate cases was there was an old lady here in Columbus, and she was really overweight. She was a hoarder. Her hobby was going around and swap meats and trash cans and pulling stuff out and then reselling them in her front yard. And she was way overweight and got down in her health. She had a yard man. It was a white guy. He was completely illiterate, could not read or write, but he was a good yard man. And as her health failed, he began to start giving her more help, like he'd drive her to the doctor. She really got down and is confined to a wheelchair. He started preparing meals for her and going way up and above, what his job as a yard man was. Well, she had a stroke. She had 2 daughters and a son who lived here in the state of Georgia. And because she was sort of an unattractive, poor, old, hoarding kind of lady, the kids, they'd call her at Christmas, call her on her birthday, but even though they lived in Georgia, she hadn't seen any of them in about 3 years. So now she's had this stroke. And even though she had a lot of junk, she had some pretty nice old antiques and all too. And so she's in the hospital. She's in a coma. You may have heard this before, but sometimes people are in a coma. You stick them with a pen, no reaction. You can talk to them, no conversation, but they can hear everything that's going on around them. This lady could too. The 3 children who hadn't seen her in 3 years, she has a stroke, come down, she's in the hospital, not expected to live. And they're in her room arguing over who's going to get what. Who's going to get what of her property. And then before it's finally determined is she going to live or die, they go back home. She lived. She heard it all. She came into my office with a yard man, wanted to make a will, leaving her house and everything she owed to the yard man. And so anyway, she died. And then I remembered that, and he did contact me because she had told him to. And I said, well, we're going to probate her estate, Charlie. You're going to have a home, your own home, and you're going. And believe it or not, the old lady had hoarded money too. He was getting probably about $80,000, which he didn't have anything, Huh, sir?
The best kind of hoarding.
Yeah, best kind. I'm sure she didn't report taxes on it either, but anyhow. So he says, I ain't got no money, Mr. Jones. I said, don't you worry about it, Charlie. I said, I like this case. We're going to take it, and you're going to pay me. I'm going to charge you a little bit more, but you're going to pay me on the back end. And so we filed it. What happened? The 3 children all caveated. That means they contested the will and all of that. Sometimes that's not a good thing. And he said, oh, Mr. Bobby, he said, that's them children's mama. He said, I can't take the house from them. I said, hell, you ain't, Charlie. I said, don't you want what she wanted? Yes. And didn't you help her? Yes, sir. I said, we're going to fight this thing. And we did, and we won. And the children all went home, one of them hired a big Atlanta lawyer to come down here, and they all left with a tail between the legs, so to speak. And we got Charlie all of that property. That was one of my favorite probate stories. You think a probate court is just probating wills, but a lot of times it's contested. Professor Tebow and I just finished a case that we litigated for over a year in probate court. It was sort of a combination of guardianship, conservatorship, and and administration because there was no will. But we had maybe 5 other lawyers involved because there was an incompetent person. And now under the law, they didn't used to get representation, but now the courts will appoint guardian ad litems, which means that this person can't really make good decisions and represent themselves. We're going to appoint a competent lawyer, a member of the bar, to represent their interests so they don't get a shaft. And so, but anyway, that was kind of interesting that we were so thrilled to get that case over with. Anyhow, that's I guess that's probably some of the things I've enjoyed the most. And then I've always read the law, and because of that, a lot of times I would find unique cases, and I stayed up on it so that I could be at, I guess what you say, the top of my form. Um, I'm trying to think what I was about to tell you. It was about a case. It was another trafficking methamphetamine case, and I had just read the law about constructive possession, and there was a law case that came out that basically said you had to exclude the possibility of other people. You could not exclude the possibility of other people having superior access to the drugs, and in this case, I did. We tried that case. The state completed their evidence. I had raised these issues. I knew that law was on my side. And you don't hear of this very often. I don't know if you've ever heard of one, but I filed a directed verdict. And this isn't a criminal case. They're granted a lot of times in civil cases. But that basically means there's no really issue for the jury. This can be decided on the law. And it was Judge Allen again, who was a real fair judge. And he kind of looked skeptically, but he was the kind of judge that he just wasn't like the other judge. Well, I never heard any nonsense like this. He went back and pulled the case out and read it right there in front of the 2 district attorneys that were trying the case against me, which that made me feel good. And need 2 of them. So anyway, and we got a directed verdict, which means the case was over and we won before we ever presented one witness. And that, people tell me they don't recall any other of those kind of cases. So bottom line is, whatever it is, your field of endeavor or whatever you want to do, you can do it. Sometimes you got to overcome a hell of a lot of adversity. I had to drop out of law school at one time when under Jimmy Carter the economy got real bad. Well, what is a freight company? Freight company moves freight. What happens when the economy goes down? People are not ordering things. I would be going out there at like noon. Well, let's see, I was still in college. I'd go out there at 6 at night, 7 at night, 1 in the morning to try, and there'd be like 40 of us, we would call casual workers out there. And the foreman would say, I want you, I want my fellow member of the Moose Club, my brother-in-law, and it didn't matter, all of us that really worked our butts off. We weren't getting to work, and I had to actually drop out of school for a year. I couldn't afford to keep going. But that's what I'm saying. If you persevere, if you decide that you want something and it's important enough to sacrifice, you're not just going to get it easy. And I tell you what, when you do sacrifice, you have a greater appreciation for it later on. So, like I said, I have told you a little bit about who I am, how I became a lawyer, what I like about the law and what the law does. And as I mentioned earlier, it looks like everybody is awake, more or less. But and here we have a gentleman who hasn't heard it all because he's late for class, as I was many times. So anyway, even though he didn't get to hear the speech, I'm ready for open myself up for either questions from either Professor Tebow or any of you. Don't be afraid to ask me something that might seem embarrassing or whatever. Just, I'm used to it. I'm a lawyer. We've sort of got hard shells and that stuff mounts off our backs, and many times work under pressure. So if you or any of you have any questions, please ask.
I'm going to start, Bobby. Thank you. Because I want to talk about something that you and I used to do together.
Yeah.
In probate court,
Yeah.
we handle estates for people who passed away, and we handle guardianships for people who lack capacity. But one of the things that probate court does, at least in Georgia, is that if there is a person with a mental illness that's so bad that they might be a danger to themselves or others, a probate court can order them to get treatment in a mental health facility, either in one, which is what we would used to think about committing somebody to a psych hospital, make them stay in there involuntarily for a certain period of time. But they also can can court order somebody to get treatment outside of the hospital once they're back in the community. And the idea is if they're court ordered to take their shots and their medicine and see their doctor, they'll stay on it and they won't end up back in the mental hospital. So one of my clients is New Horizons, which is handles mental health and substance abuse treatment for indigent people in our area. And we will bring on behalf of New Horizons a petition asking the court to put somebody under mandated treatment. And it's a pretty high standard to meet because we put a lot of value in our country and in our laws on individual liberty. If somebody wants to be crazy, they can be crazy. We draw the line kind of where you can't be a danger to yourself or others, but we're free to be crazy. And so I would bring those petitions on behalf of New Horizons, and Bobby would be the court-appointed attorney for the individual that we were trying to commit. Well, many times the folks that we were trying to commit they were not doing well. If they were doing well, we wouldn't need to have them in court. And so we would hear the most outlandish things from these folks. I mean, Bobby's clients would be the King of England, the Queen of George Washington, and you name it, had these delusions of grandeur. But Bobby always handled their cases with a lot of compassion because I think we knew we were all there trying to help the person. It really wasn't adversarial where maybe like in some other cases, but he always did an excellent job, I thought, of having compassion for those people. And I was always scared. We don't do it anymore, but I was always scared he was going to trip me up on something really technical because he knows all that, and that's one of my weak spots. And so every once in a while, Bobby would say something that I wouldn't really have a good answer to. So he always kept me on my toes on that. But it was before my time, but I mean, one of your clients one time told the judge he had remembered sleeping with her, right? You remember that one?
Yeah.
Anyway, we'd come up with some crazy stuff.
I'm glad you brought that up, and I meant to. And prior to representing people facing involuntary hospitalization, outpatient commitment, for over 20 years, I'd represented people facing involuntary hospitalization at West Central. And many times somebody would talk about I was doing a good job. And I remember one time Judge Rudy Jones, at one time was a probate judge, he said, yeah, we appointed Bobby to represent all the, he should say mentally ill, but he said the crazy people, because it takes one to know one, you know. And so, but speaking of those funny things, you probably shouldn't do it. You're not supposed to always do this, but I would tell my client, don't mention this. Don't mention the mafia living in your attic and, you know, and things like this. I just tell the truth, but don't volunteer. Don't bring this up. I'm afraid they might think there's something wrong with you, even though we know there's not. You know, yeah, all right, wink, wink. And but anyway.
And that's the one thing they can't wait to tell.
Yeah.
Is what you tell them not to.
One time there was a guy out there, he presented real well. I was talking to him before, you know, we had the hearing, and I asked him what day of the week it was. He knew that, and I asked him, you know, all kind of things like that, who the president was, what month it was, and he was doing real well. So we came in, and he was doing real well again. And another guy that was out there at the same time, he was my next client to come up, thought he was president of the United States, okay? And so we got in there, and then the judge started asking my client. He said, what month is it? He told him, what day is it, all of this. He said, who is the president of the United States? My guy went like, I can't remember, but he's sitting right out there, you know? So that kind of did his case in. But
well, lots of times Bobby's clients would do really well for the first 5 minutes, and you would listen and you would think, well, why are we here on this person? They're doing really well. And I always had New Horizons employed a psychologist who was an expert witness, and she had evaluated the people and recommended that they needed treatment. Well, I would always have her before the hearing tell me, what are the couple questions that I can ask them if they're doing well to show, maybe what some of their delusions were. So he had a client that was doing really well, then I might say, well, Mr. So-and-so, you're president of the United States, right? And then I'd get them going.
Yeah.
But usually the thing that he didn't want them to say was the one thing that they could not wait they're bursting at the seams to say. But that is an interesting thing. Another question I have for you, Bobby, is because we talked some about search and seizure and excluding evidence and police needing warrants. Does that come up much? Do you make many motions to exclude evidence? Do y'all fight very much about that?
Yes. It's motion practice. So when you can file motions like this, I'll give you an example. In Harris County, adjoining county, I had a case one time, and there were about maybe 3 defendants, and the Harris County Sheriff's Department members had seized about 11 ounces of methamphetamine, a moonshine seal, explosive devices, a lot of other things. But anyway, and so it was, in my opinion, an illegal search. And so I had researched the law, and a lot of times Harris County made me a lot of money up there, I tell you, because they had a guy that used to be with Metro Narcotics here, Jim Price, and he's now like a assistant sheriff up there. He's the one up there. And then, well, I shouldn't call their names, but then another fellow that's up high in the sheriff's department. But they were cowboys. They'd do what they wanted to do. If they thought you were doing something, they'd just come on in, and it didn't matter they didn't have a warrant or needed to get a warrant or whatever. And so they knew that this operation was going on at this place, but they could never really get it. So one time they had noticed that my client who worked there had an expired tag, and they didn't do anything about that and all, but they kind of found, reasons to later on. They kind of laid in wait for him to be driving to work, blue lighted him, pulled him over, found a pistol in the car and some other things, and asked him where he was going. He said, I'm going here to, open up shop and la da 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 da. And so they said, well, anybody can get your car? And he says, yeah, the guy up there that runs the place, he'll get, I can leave my car there. So they put him in the back of one of the sheriff's vehicles. The other sheriff drove his car, and they all went up there to where this place was. And at that time, it wasn't open. And under the guise of wanting to find out who had who could take this fellow's car, they really didn't care about his car, to tell you the truth. They were just looking for a reason to come on the premises because they didn't have enough to get search warrants. And so they went up there. There were Doberman pinchers behind fences and doors where they couldn't get in. And then they started looking around, which they don't have a warrant now. And they saw a marijuana roach in an ashtray sitting over out here, which really could have been by anybody because it was in a public area outside the locked up premises and everything. But anyway, they didn't go, that would have allowed them, except technically they shouldn't have been where they were when they saw it, but arguably they could maybe have said it was in plain view and gotten a warrant. They didn't get a warrant. They just went on in and they found 11 ounces of meth, moonshine steel, automatic weapons, explosive devices, blah, 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 blah. Well, I filed a motion to suppress in that case. And also there was another technicality where they were going to forfeit all of these things to the state together with all the money they took there, the automobiles and guns, everything. Number one, that case went on, and I had a co-defendant represented by Attorney Clark Adams here in town. And sometimes we don't read the law like we should, but he read the law and found out that hearing has to take place in 60 days. Well, it was a complicated case, and the DA had continued it 2 or 3 times. And we got up before a judge, and we laid such a good argument of why. Now, this time is just to get the things back, not trying the case. And he found that loophole in the law that had to be tried. And I don't mind calling this one's name, Judge Bobby Peters said, and I'm still practicing before him. So
No
I
comment.
hope you're not watching this, Judge Peters. But anyway, he just said, well, I don't know. We're just waiting to decide this. If they win the case, they can get everything back. If not, they won't. And we objected and tried to tell him about 60 days, and he didn't want to hear it. So he didn't. And anyway, we finally stuck the law in his face or threatened to appeal. And we got, number one, we got all that stuff back. Number two, I filed a motion to suppress, which means that this evidence was gained illegally and cannot be used in trial against the defendants. So what I do, I suppressed 11 ounces of meth, automatic weapons, explosive devices, a moonshine still, all of that. Well, without that to come into evidence, they had no case. Everybody went free, even though we know that, well, my client actually wasn't guilty technically. He was an employee there. And anyway, but everybody got free on that. And so it's important to always fight it with every weapon you've got. And like illegal statements, like the cops, hold somebody for a long time and threaten them and maybe beat them or whatever, or withhold food or whatever. And you can get what they said suppressed, so they can't use it in trial. It's the same thing with physical evidence, and that's what a motion to suppress. So a lot of times in like trafficking and drug cases and all, even though I don't approve of trafficking in meth, I've seen many of clients of mine who were ruined by methamphetamine. Teeth all falling out, they lose their brain. Beautiful young ladies, 4 or 5 mug shots later, look like old witches, and people addicted to crack cocaine that they're stealing from their own parents and all. I mean, I can see the bad parts of it, but remember, my job is to represent them. Let God judge them, And if they're going to be convicted, let it be by fair and honest and constitutional police work, not crooked things coming in and taking advantage of people. So that's how I feel about that. And that's why it's important to pick it apart and to find, because if I had not filed these motions to suppress or read the law, a lot of these people would have been convicted and they weren't.
Do you like, would you rather have a jury or just a bench trial in front of only a judge?
Well, if it's a completely legal defense, then, and I'm not going to call names here, but some judges, it doesn't matter, they're going to rubber stamp what the DA wants. They still do it. And I would rather at least try it before a jury. Mm-hmm. But the only time I would want to try it before a judge is when it's maybe a bad case for me, but yet there's technicalities that maybe, such as like a DUI case where the officer did not perform his field sobriety test correctly. I mean, it's supposedly a science, but they've still got to do it correctly or it should be invalid. And so sometimes you have to attack it on improper police procedures, and you figure the jury's going to say, well, the guy, look at the video, you're staggering all over the place. When he had to walk to the back of his car, he was like holding himself up on the car, and he said, I like this, and it's crazy. And so you want to try that for a judge. But a lot of times you might have some emotional things, or you may have some bad police, and you want to have a jury then. There's an old saying, John Swearingen used to be one of the best criminal defense lawyers here. He said, if the facts are against you, you argue the law. If the law is against you, you argue the facts. If the facts and the law are against you, you try the police. That's what he said, or wear a loud tie. And so that, anyway, that was something.
So jury selection for what you do is pretty important.
It's most important. And there's a lot of times, especially I learned this in the child molestation case, there's people that won't raise their hand that maybe were molested as children and nobody was ever caught. I mean, I know this to be true. And that will lie on voir dire, as we call it, when we're questioning jurors, and they will already have their mind made up. I found this out. Like, let's say I had a felony shoplifting, and I look at the jury, ladies and gentlemen of the jury, this is a charge of felony shoplifting where the defendant, and talk, and the jury's still kind of looking at me, listening like we're willing to listen, But then when I say, ladies and gentlemen, this is a charge of child molestation. Oh, you see the jury, oh God, we're gonna hang that son of a bitch, you know. I mean, before they've even heard it. So what's important about that? If you ever get to serve on a jury, don't make your mind up when you hear the opening arguments. Don't make your mind up when the state has completed their prosecution. Keep your mind open till you've heard the entire thing. That's what you're supposed to do anyway. And then go back in chambers and weigh it all together and see that the constitutional rights were protected, and try and make a just decision. In civil law, the burden of proof is only to prove by a preponderance of the evidence. That's the old scales of justice. Is it more likely this way or that way? In a criminal case, you have to prove a client's guilt beyond a reasonable doubt. Beyond a reasonable doubt. It's not beyond all doubt, but a doubt that a reasonable person would have. I look at it like a football field. Most of you know what football is. In a civil case, if one side goes past the 50-yard line, well, it's more likely that they win, and so they get to win. But in a criminal case, the state's got to carry that ball all the way down and score a touchdown, and not the client walks free. And again, this is to try and keep it fair, because if you think about it, the state has paid witnesses, cops, police, and do you think a policeman will come in and say, no, yeah, he's really innocent, we screwed up, I mean, I don't think he's guilty. No. But the defense lawyer's got to go out and dig up people that really don't want to be in court. Hell, if I come in here and testify with him, the cop's going to get me next week, things like that. But it's kind of a loaded, and still, even though we've got a pretty good DA's office now and things are much more fair than when I began, the ball is still always in the state's court. Like I say, they have paid investigators. Me and my secretary might be our investigators going out to a scene. That was another case that I think I'd like to say something about. I had a case one time. It was a burglary case, and they had caught one of the burglars. The other burglar had gotten away. And so after they made that burglar a deal to get out of prison early and come and testify against my client. So what do we have here? We have a co-defendant coming in and saying, yeah, I did it, and so did Mr. Jones's client. And we had a police officer saying, yeah, he did it, and I saw Mr. Jones's client running from the scene. And my guy just kept insisting he was innocent. And I didn't think he was innocent. This is where you mess up. I didn't think he was innocent. And he wanted a trial. I'll tell you, I suffer from anxiety and depression. I didn't take medication for years. Now I do, and I haven't been depressed in a long time. But I got really depressed. I said, I'm going to look like a damn fool up there trying to try this case when you've got the co-defendant saying he did it and my client did it, and you got the cop saying I ain't mistaken, it did it. And I was really getting down about it. And finally it dawned on me. I said, if you keep saying you're a damn fool, this case ain't got a chance to win, you're not going to win it for sure. I've got to be positive, because think about it. If I do win it, I'm really doing something. Mm-hmm. And my secretary said, yeah, you're right, Bobby. And so I said, let's go out to the scene. We went out to where it happened. We took photographs, tried to imagine where the policeman was standing, where this would have happened. And anyway, we turned, when we got out there, and the cop said that he saw, borrow this for a second, he said that he saw my client running from the scene. Well, we've got these apartments for a quadruplex, and the victim was down in this apartment. I don't remember if a burglar alarm went off or something summoned the cops. And only one cop's there at first, and of course he's not going to enter because he thinks everybody's inside, and he just takes up a position. So I figured, where would this cop stand if that's what he's doing? So then we figured out probably where he was standing. And then I said to my secretary, first of all, here's the apartment building. There's a big old oak tree right here. There's high hedges right here. here's the corner of the apartments, and we surmised that the officer was probably standing about right here. Turned out that's where he was standing. I read in the report, because you carefully read things, that he had tripped. We looked around, and there was another big tree right here, and there were roots above ground. Oh, I said, Tammy, that was my secretary. I said, I bet he tripped on these roots and everything. And so, anyway, the co-defendant was an idiot. I mean, not the co-defendant, their witness who actually had done the burglary. What happened was he had done the burglary with somebody else, a guy he was afraid of. And he wasn't going to give this guy up. And he was really illiterate, and he gave a written statement that was all jumbled up and talking about this and that and the other. And I was able to get that into evidence and convince the jury that it was somebody else, and he was afraid of this guy. And then I just got lucky too, because we were breaking for lunch, and the convict who was testifying against my client really didn't want to be there. And I'd already had him on cross some until we took a recess, because as the judge said, it looks like Mr. Jones is going to question this man all day, so we're going to break for lunch. And I happened to hear the DA tell the police officer, don't let him get out of your sight, at lunch and everything like that. And so anyway, they come back from lunch, and the DA, not knowing big-eared Bobby's back here listening, said, is he back? Said, yeah, I took him to lunch. I bought his lunch. So my first question when the officer took the stand said, where'd you eat lunch, officer? And they looked at me like, what the hell does that have to do with it? And who'd you have lunch with? Do you have a habit of taking convicted felons to lunch? Anyway, I made it look like this guy was kind of compelled to be there, so to speak. And then, because we had taken all these photographs, well, anyway, we shot that client. We went up one side of him, down the other. I mean, we just ripped him apart. Then the officer's up there, and he was a really fine officer. He's an honest officer. I'm sure that this officer really felt that my guy was the guy he saw. But when he got up there and testified, and I said, where were you standing? And he basically right where I thought that he was standing. That's where he said he was standing. And I said, and you tripped while you were, I said, and then what happened? He says, well, both of them came running by, and I saw him run by here. I got a good look at him when he ran by, and the DA had said, and do you see that man in the courtroom? Well, hell, there's only one defendant, and they always say, yeah, it was him. I mean, who else can pick somebody out of the jury or the audience? No, it was him. That's what they always going to pick. That's the old thing they do with the state. I'm sure it was him. And then so I said, well, Officer Graydon, I said, you tripped while you were back there, didn't you? He said, yeah. Like, how did you know? Well, it was in the report. But he didn't think it mattered. And I said, there's a lot of tree roots back there, isn't it? And he said, yes. I said, is that what you tripped on? He said, yeah. And I said, so let's get this straight. This is where you were standing. And so all my photographs are standing in front of this big tree coming back this way. So you're seeing all these pictures. But I also had pictures from back here showing this big tree. So what happened? We got a guy running. An officer takes a step forward and yells, freeze, whatever. And he trips. So then this big tree's here. We're talking about probably from that wall till about here would be the space the guy was running across. Maybe more like this, really, from here to there. And this big tree's out there. Well, we established that he tripped, and then he saw him here, and that was like 1 second and 1 second. That's 2 seconds that he got a look at this guy. And we tore the co-defendant apart. Anyway, if you ever want to look and see what this guy says, of course, he says I was innocent. But I've got a website. It's attorneybobbyjones.com. And you can see what a lot of people have written that I represented, that you'll see that a lot of them were innocent, or I have helped a lot of people out. But anyway, the offer started out with prison time. Right before I went to trial, the district attorney, realizing that she had a kind of a reluctant witness, so to speak, and they knew I could impeach him. That means show that he was a convicted felon, that he's not really worthy of belief, and you can get the judge to tell the jury that at the end. If you find that any witness has been impeached. And I charge you that impeachment can be by inconsistent statements, by proof of conviction of a crime of moral turpitude, da 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 da. So she knew it was a week. She offered 20 years probation. I said, "Oh, I got you probation, man." No, I'm taking that, Mr. John. I said, "You crazy? You want to go to trial?" He said, "Yeah." I said, "You got the co-defendant saying you did it? You got the cops?" "Yeah." Well, that was the trial we went. We won it. Everything, you know. Another case I had one time.
Was that the best offer y'all got? Was 20? Did they keep sweetening the offer?
When we won the trial, yeah, they offered when they saw we were going to try it 20 years probation. It was a long time. And my guy did have a prior theft record, but he was not. Since this case had happened, he had completed junior college, was working, and had not committed any crimes except the one he did back when he was 17 years old, a burglary. I mean, a theft case. He stole like a lawnmower or something, you know. But that don't mean he's going to do all this. So I had another case one time where you had a robbery of Mr. Bone, who owned, excuse me, Valley Produce here in town. Turned out, we found out that his son was a bad coke addict and was dealing coke. Talking about the victim of the crime. And the son would manage Valley Produce for him, but we found out he owed a lot of people cocaine money and things like that. And actually, he engineered the robbery. And what happened was, my guy was a white guy. The other defendants that actually did the robbery were black, and they had done several robberies. And here's what they'd do: white guy drives in with all the black guys down in the car, and then when they drive away from the scene, you know, and they pass. In this particular case, they had 3 or 4 police cars, blue lights coming past them. What are they doing? They're looking for like 4 or 5 black guys. Instead, they're down in the car, and my white guy's driving. You know, is what they said happened. And the last thing I told him, we got an offer on an armed robbery, you got to do 10 years at least. But they had an offer to me to reduce it to simple robbery and give him 5 years, which he could have been eligible for parole and be out in 2, or he could maybe even get up to 20 years. And he wanted to go to trial. And the last thing I said to him before that trial started, because our witnesses was his dad and his sister. Anyway, that was our only witnesses. And then you had all these co-defendants saying they were going to testify, you know, against my guy. They did it, and my guy did it. The last thing I said to my guy before we cranked the jury up, I said, "You know, I ought to plead you insane for not taking that deal. It ought to be an insanity defense." Well, it turns out that during the day before trial, the district attorney, and since he's dead, I won't call his name. He became a judge later on. But I'll tell you, he would sandbag you. He would keep evidence good for your client hidden. He was really dastardly, is a nice word for what the kind of DA he was. He was dirty, you know. In fact, he had to retire from judgeship for tipping off some people about some improprieties going on in Talbot County, but that's another story. And I found out from 2 other lawyers who represented 2 of the co-defendants. Now, they had all pled guilty. Why? Because this DA made them deals. If they would testify against my client, you know, that he was going to see to it, because they had pled guilty, but they had not been sentenced. See? Mm-hmm. And now he wants them to testify for them. So they're going to say whatever the DA wanted them to say. And so one of them was on the stand. Well, anyway, I talked to a couple of other lawyers, because you can't go talk to another lawyer's client without his permission. And they said, "Well, we'll tell you that unnamed DA was over there. He wound up becoming a head DA at one time. You know, I'm talking about, I'm sure. That he went to see the co-defendants in jail yesterday and made them these offers, you know. And so I knew that. And I said, "Well, y'all come to court?" Oh, no, we're not going to get involved. These 2 are my good friends, Attorney Richard Dodelin and the late Vance Penner, who was a public defender at that time. No, we don't want to get involved with it. And these are good friends of mine. So what did I do? I subpoenaed them. And I said, "You're going to be there tomorrow. I'm sorry," you know. And then I told them to go stand outside the courtroom, and then the bailiffs at some point may come to the door if this thing works, and all I want you to do is stick your heads in the courtroom. So the main witness against my client just burned my client, you know. And then did the district attorney talk to you about this case? No, sir. He didn't tell you what to say? No, sir. He didn't come visit you in jail yesterday? No, sir. And offer you a reward, a benefit, and that's part of the charge. If you offer a benefit or reward, it's no good in the law. And a benefit or reward, he offered to give you less time? No, sir. And I said, I'm through with this, Whitney. Sit down. And so they stepped down. It was Judge Ruth McCombs back at the time. And I said, Your Honor, I've got a motion to be heard outside the presence of the jury. So they excused the jury because, you know, you don't want them to hear it until it's ruled admissible. And I started telling, we had a bench conference. That means me and the DA walk up there to talk to the judge quietly. And I told him what I just told y'all about this. His main witness just lied. He's lied. The DA offered all this stuff like that. And he said, no, I didn't, Judge. I said, Mr. Bailiff. That was the signal, just Mr. Bailiff. And then there comes their lawyers stick their heads in the door just to show that they're there. And the DA he almost turned white. And he went from, oh, I didn't do this to Judge McCombs, after she reconvened the jury, made him basically tell the jury that his lead witness against my client had just lied. And we got a not guilty verdict. So anyway,
Nice.
That's probably the last story I want to tell.
Well, and we ran out of time, so I did not.
No. I wanted them to ask questions.
I did not give y'all a chance to ask questions, so I apologize.
Is there another class coming in here?
No.
Well, of course, be like I was. As soon as the teacher said it's over, go. But if
you want to stay and ask questions,
yeah,
Mr. Jones is saying he'll stick around.
Professor Tebow, I'd be happy to take the question. I won't be offended if y'all get up right now and leave. I'm just thankful y'all are awake still.
So if anybody needs to leave, you are welcome to. If anybody wants to stay and ask questions of Mr. Jones, you're welcome to do that too. Y'all will have an assignment on this. I'll post it this afternoon. It'll be to turn in 3 things that you learned or found interesting about Mr. Jones's remarks. So don't forget, that'll be due Monday night. All right, if you must leave, we'll see you later. If you want to stick around, please do.
And if my daughter's watching this tonight, don't be asking me anything. You should have watched it and answered it truthfully.
And y'all help me thank Mr. Jones for coming today. We appreciate it.
Thank you.
I had so many questions. I'm sorry. I boxed them
I can talk
out.
to you probably, but if anybody else has any questions.
You actually answered one of the questions I had.
Yes, sir.
Like, I wanted to ask you, like, if you had a client who was innocent that you thought was guilty, and you actually answered my question for one of your cases. Do you have any other clients that you thought were innocent, that you thought was guilty, that were innocent?
Yeah, I've had a few of them, and I've had a few of them that I thought were innocent that were guilty, and guilty that were innocent. And only until after all the evidence came back, you know, and the trial was over, did I really know. That's why I say you keep your mind open until you've heard everything, then make your decision.
Yeah.
Thank you.
Good question.
Well, thank you so much.
So, what would happen if you're defending someone who is accused of a crime, and you thought they were innocent, they thought they were innocent, and they end up getting convicted, and they're charged with the crime? Do you just like say, well, that's just the law, that's how it works, I got to move on to the next case, or do you keep them in mind and maybe try to work out something else for them?
Well, do you remember me telling you about depression?
Yeah.
I get down.
Yeah.
And I really feel like I kind of punished myself. Was there something else you could have done? And of course, when you look back on something, you think of all these things you, in the heat of the moment, you didn't think about. And you kind of beat up on yourself. I had the first shaken baby case in this circuit. And it was horrible. And we changed the law a lot. I lost the case, lost the appeal, but we changed the law. I argue that shaking baby was voodoo science. And it turns out just in the last 2 weeks, I heard it, where they have decided that it is voodoo science. and that there are other explanations that a child could get subdural arachnoid hematoma, diffuse bleeding in the cranial cavity, or petechiae, which is a little blood in the eyes, other than violently shaking a baby. And in that case also, I objected that the district attorney talk about my client, he was on trial for murder and cruelty to children, that he object to calling it a homicide and calling it a murder. And I argued that is for the province of the jury. And the judge made him not do that, which handicapped him a good bit. And also, I had the charge nurse, and anybody knows medical field, a charge nurse is the lead nurse in the hospital that basically is probably knows more than a lot of doctors. This doctor in the case was a resident. In other words, he just graduated medical school. He was at the medical center, and he was really a handsome guy. He could be a TV doctor. And I'm telling you, I mean, really handsome guy. And especially the ladies on the jury, they were almost swooning when he would testify, and he was wrong. The charge nurse testified for me and was right. And we found out that the child had gone to a pediatrician a week earlier, and this pediatrician misdiagnosed the child. What had happened, you know, the old-fashioned barber chairs, they're metal and heavy and have a metal thing. This child that died was 8 months old. That's in the pulling up stage. Before they learn how to walk, they can grab and sort of pull them things up. And what happens, he pulled himself up at the foot of that chair and fell and hit his head on that metal there. And the parents grandparents took him to the doctor, and he misdiagnosed. And what happened is he fractured his skull at that time, which led to what you call diffuse, meaning full of blood, in the subarachnoid, subdural hematoma. And what happens is when that blood swells that brain, it's a coup contra coup injury. Then what happens is it can go down, and your brain stem is right in the back of your neck, and then it can immobilize you, lose your speech, or sometimes make the child not be able to breathe. And that's what happened here. And it was really because of a misdiagnosis from a pediatrician coupled with a handsome doctor saying, no, it didn't happen that way. I mean, I had hired a 25-year nurse to educate me on this stuff. And get this, I got appointed to this case. Back then, we didn't have full public defender's office. I'm on another case out in Talbot County, and the judge appoints me to this murder case. It's going to be a trial in 2 weeks. So I had 2 weeks to get ready and do this murder case. My client was actually at Fort Jackson because he loved his family. He had joined the Army because they were tired of living with his parents. He wanted to support his child. And we even had people from First Baptist Church testify that, unlike most young parents, every time they came, they had the bag with bottles, changes. That was a well-kept, well-nourished, nice child, that sometimes the father would even come in during the sermon just to check on his baby. This is the father that was charged with the murder. Well, so anyway, I hired a nurse to teach me all this stuff, and I got into medical books. And I'll never forget that same DA I told you about earlier that became a judge and then got removed as a judge for being crooked. Basically, he tipped off the Talbot County Sheriff's Department that the FBI was investigating. I remember him saying, it looks like Mr. Jones read some kind of medical book, get ready for this, because I was cross-examining these doctors, bringing out other reasons.
You're daggone right.
And so I don't remember how we started on this.
Well, if you have
Oh
somebody,
yeah, and I felt that guy was really innocent, and I felt that they were invading the province of the jury for this doctor to give that expert opinion because he was a resident and he was a general resident. This would have taken like a doctor that was
he wasn't enough of an
a
expert in that
neurosurgeon
area.
or something. Yeah.
Well, if you have a case like he was asking where you feel like the jury made a mistake or, just justice wasn't served, do you always sit down with your folks afterward and say, all right, let's look for some things to appeal? I mean, how does all that work?
Well, now I don't
after trial, it's not over.
Yeah. Well, you have 10 days to file a motion for new trial. And the reason you file that is not that you have any hope of winning it, but if you don't do that, you would have to appeal this case in 30 days. And then a lot of times it'll take several months to have a complete transcript. So you always file a motion for new trial, even if you don't feel you got a chance to win it, just to keep that open. And then I had done appeals, but it takes up so much of your time that I always try and get the judges to appoint somebody, arguing that they used all their money hiring me to begin with. They ain't got any money now, so they need an appellate lawyer. And so, yeah, especially and in that case, remember he was charged with murder, cruelty to children. I got a not guilty verdict on the murder, but I think the jury balanced, but there's a child that's dead here, and they found him guilty of cruelty to children, which is a felony, which they didn't used to have this, but about a year or two before that happened, they had a crime of felony murder, which means that if somebody dies in the commission of a felony, then you still get life in prison. So this father, who I still, even to this day, felt was innocent and wrongfully charged, and is due to a misdiagnosis from one physician and a sorry opinion from another, but he happened to be so handsome and that they just went with what he said and disregarded my charge nurse that told me privately she felt like turning that doctor over my knee and spanking him, you know. And,
So your guy got life in prison?
yeah, he did 13 years. While he was in prison, he was picked on and everything. You get in prison, you did a child molestation, they're going to mess you up if they can. And he fought it. He was jumped on one time, and the prison guards, now they don't give a damn about anybody. They come in breaking up the fight with their billy clubs, and I hit my guy, broke both of his knees. You know, this is that innocent kid that had no prior record, who had, I'd been in the band with his mother at Jordan High School, and I mean, and they were good. They're real religious people, and I knew he was innocent, but he did about 13 years before he got out. And today they're saying yes, like they don't say like Mr. Jones said, but yes, that is voodoo science. That's junk science. And yes, and they said in the appeal that at the time that this was made, what Mr. Jones objected to was not the law. But henceforth, we're going to make it the law, but they didn't reverse my
They
case.
didn't reverse
But
it. So if you tried that case today, what the prosecution's theory, they would not use that science anymore.
they try to, but
try
I
to,
think
but-
we now you get experts say that's junk science and
Gotcha.
everything. So anyway, is there anything else?
I'd like to take a picture with you real quick before my next class.
Oh, I would be thrilled. Thank you. Any other questions? Thank you all for
Y'all-
your interest.
Will y'all all come down here and let me take a group picture too, just in case, because we use this kind of stuff.
Nice to meet you.
Professor Tebow would do it. What's your name?